How do you toll the statute of limitations for a foreclosure action? To find out, you have to read Batavia Townhouses versus Council of Churches, but it's 35 pages. Don't have time for that? I've got you covered. Too long, didn't read. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on Batavia Townhouses versus Council of Churches. This can be found in 2022 New York Slip Opinion 03361, published by the Court of Appeals on May 24th, 2022. This is a civil action, and it's a real estate law type case. The issue in this case is what sections of the law apply with respect to tolling the statute of limitations for a mortgage action. I'll explain that in a second. The background you have to understand this case is that every action has a statute of limitations, which is a time period from the moment the action accrues, meaning all the elements exist to file the action, to the end of the statute of limitations period. You have to file within that period of time, or else you're subject to dismissal after motion for being untimely, for filing beyond the statute of limitations. Now, the statute of limitations can be 1 year, 2 years, 3 years, 20 years. The statute of limitations for mortgage actions, for mortgage foreclosures, is 6 years. And you have to understand that there's two sections of law, amongst others, that address tolling of statute of limitations. One is General Obligations Law, GOL, 17101. Another one is GOL 17105. GOL 17101 says that a signed and written acknowledgement that the debt exists, an acknowledgement of a promise to pay, a contractual obligation, will toll the statute of limitations, except when it relates to an action for recovery of real property. And GOL 17105 says that for actions related to recovery of real property, a signed written acknowledgement is not enough. You need an express promise to pay the mortgage, or an express promise to waive the statute of limitations. So there's two different things that are required for 101, for every contractual obligation apart from real estate transactions or recovery of real estate. A written acknowledgement is sufficient, but for real estate transactions, for recovery of real estate, you need an express promise to waive or express promise to pay. Now let's talk about RPAPL 1501, Real Property Actions and Proceedings Law 1501, says that when the statute of limitations have expired for recovery, for foreclosure of a mortgage, foreclosure of property from a mortgage, then a borrower, person with an interest in the property, can file an action to unencumber the property. So a mortgage is an encumbrance upon the property that follows the land until it's paid off, or until the court removes it. And if the lender, the person who gave the mortgage, doesn't pursue it, doesn't file an action to foreclose the property and take the interest in the property within the 6 years of the statute of limitations, the borrower can say, too late, you've exceeded your statute of limitations. I now want the court to unencumber the property, to say the mortgage is dead, and they can do that. So, what's the facts of this case? The defendant in this case, Council of Churches, took out a loan with a mortgage to build Birchwood Village, which is a low-income housing unit. And they defaulted on that in 1979, and HUD, Housing and Urban Development, which is a federal agency, took the mortgage, and they were going to foreclose on the mortgage until Council of Churches gathered a bunch of private investors, formed a partnership, and basically put a second mortgage on. So now they put a second mortgage to pay off the HUD loan, and this partnership would have a second mortgage, two mortgages now encumbering the property. They successfully start paying off the HUD loan, and by 2012, they pay off the HUD loan. But there's still that second mortgage that's encumbering the property. And the Council of Churches is a member of the partnership, but they don't require payment of that second mortgage. It stops being paid for 7 years. Other members of the partnership get upset and have a dispute, and they file an action to say, I want you to unencumber the property, court, because they had not paid the mortgage, and the statute of limitations is 6 years. It's now 7 years. So you should unencumber the property. Then Council of Churches says, no, wait a second. We don't want you we want that mortgage paid, And you have to look at the fact that in the last several years, we've been filing these financial statements, written acknowledgments of this debt. That satisfies GOL 17101. So it told the statute of limitations. And it goes to the Court of Appeals, and the majority of the Court of Appeals says, no, it does not, because it's a mortgage. It's about real property, not about a contractual obligation to pay. And because it's a mortgage, an acknowledgement to pay is not sufficient. You need that 17105 language, an express promise to pay the mortgage, or an express waiver of the statute of limitations. And the financial disclosure documents acknowledging the debt is not express promise to pay the mortgage or an express waiver of the statute of limitations. But there is a dissent here, and the dissent by Judge Wilson says, wait a second, you're forgetting the fact there's a note and a mortgage. The mortgage secures the note. And he would send this back down to the court to determine whether or not the financial disclosure document satisfied 17101 with respect to the note. But he agrees that with respect to the mortgage, only 17105 would toll it, and that requires an express promise to pay. So 2 loans didn't read, Batavia versus Council of Churches. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.